It's not a legal requirement to obtain consent in all cases. The key point is that schools are acting reasonably, fairly, openly, and in accordance with people's expectations. Therefore, parents and older pupils should be given information about any filming. So, for example, what the filming is, what it will show, where it will be published. This information is normally provided in a document known as a privacy notice, which tells pupils and parents about the information the school is using, including videos. It's useful for a privacy notice to be as open and transparent as possible, so use of examples is great, and making it accessible to pupils as well, so written in a way that's easy to understand for pupils. If a video is specifically going to be quite privacy intrusive, it's best practice to get specific consent for that video. So, for example, if a school wanted to use a video interview of a child and publish it on the website, I would recommend getting specific consent for that type of video. Consent must be specific and informed. This means that the person giving consent should understand what the video is going to show, why it's being used, and where it's going to be published. Children are generally considered old enough to exercise their own data protection rights when they're 12 years or older. However, this isn't a hard and fast rule. Teachers will need to use their professional judgment to decide if a child is mature enough to understand the consequences of a video being used. But as a general guide, then children who are aged 12 years and older, as well as their parents, should be provided with any information about filming that's going to take place. If a school decides that because a video is privacy intrusive that they want to get specific consent, then the age of the child will help them to decide who should give that consent. Now, the law is not prescriptive on this, so teachers will need to use their professional judgment. One option is where the child is aged under 12 to just get the parents' consent, where the child is aged 12 to 16 to get both the pupils and the parents' consent, and where the pupil is aged 16 or older just to get their consent. However, this is a general rule of thumb, and teachers will still need to consider if the child is capable of understanding the consequences of the video being used. If they're getting consent from the pupil, it doesn't have to be written consent, and in fact it can actually be better to have a conversation with the pupil, because this allows the pupil to ask them any questions and the teacher can make sure the pupil understands what they're being asked to consent to. As well as the privacy notice, which I've already mentioned, which will explain the different types of information used by the school and should include reference to videos, I would recommend that schools have policies in place that give guidance to staff about using videos. If a school has an early years setting, then their safeguarding policy should mention the use of cameras. Schools should also have rules in place about how long videos are kept for, and videos must be securely deleted when they're no longer required. If a pupil or a parent feels that a video shouldn't have been used, or they should have been asked for the consent and they weren't, then they can make a complaint to the school. And obviously dealing with complaints can be time-consuming and resource-intensive for in schools. Individuals also have the right to complain to the Information Commissioner's Office. The Information Commissioner regulates data protection compliance. And the Information Commissioner has the power to take various types of enforcement action. The enforcement action taken will depend on how serious they consider the complaint to be, but one of the things they can do is fine schools up to £500,000 in extreme cases. Now, obviously, there's also reputational damage can be caused if a complaint becomes well known. So it's really important that schools are managing parents and pupils' expectations about using videos and getting specific consent where a video is particularly privacy intrusive. An example of a privacy intrusive video would be something like a video which is focused on either a few pupils or one pupil. So the focus is very much on those pupils, and it's going to be published somewhere which is public, so a website, for example. I consider that to be privacy intrusive. That's a public-facing website which is accessible to everybody. So if a video is privacy intrusive towards the pupil, then that would be something where they should probably get consent. I have to say the law is not prescriptive on this at all, therefore it really is up to the schools to think, what would parents expect in this situation? What do our older pupils expect in this situation? And essentially managing everybody's expectations about what the school's going to be doing, because then you lessen the chance of a complaint being made.
Don't forget to watch the rest of this series to learn more about creating videos for you and your class.